therapist who, quite frankly, doesn't even know Miss Olvera. So the issues are very intricately intertwined with regards to an extension. An extension is generally asked for when it's in the best interest of the child, as well as mom, who is also an abused child and barely an adult when this case ensued, by the age of 18. And the whole thing is we can't even do anything to finish out, and she's got perfect compliance on everything else, Your Honor. She's making progress.
Okay. Ms. Johnson, can I stop you for a second?
Sure.
Because I want to give you all the benefit of my thoughts. I don't think that those issues are as intricately intertwined that they can't be dealt with separately. I understand they bleed over to each other, but that's one of the reasons why I wanted to have this hearing separate and first. There could be any number of reasons that we would grant an extension. One could be that the court is just allowed to retain the case on the docket because of the COVID-19 pandemic and the governors and the Texas Supreme Court's rules. It could be based on good cause for either of you. If it's based on good cause for one of you, then the other one gets the benefit of that. There are other reasons it could have been granted, and going into it, it would seem likely under the circumstances with Mr. Collins' client incarcerated and with the current rules allowing these, and to give everybody a full opportunity to be prepared, it seemed likely that we would be headed toward granting something like this. Now, if that's the case, then we have to deal head on with one, the intervener. Well, it seems to me that under the rules that the intervener, whether I don't know if that adds anything or detracts from anything, or is it my call to say if it adds or detracts when you have an intervener? The CPS is taking the lead. They're entitled to take the lead. What the intervener is going to do, I'm not sure that they would not be stopped from taking a different position from the department. Sometimes they have been based on their contract. So I don't know, but it appears that by extending, then by statute, they're allowed to intervene. So then what do we have? We would then have, how do we deal with mom and her service plan in between? That, Ms. Johnson, I believe that we would take on head on, hear from everybody about that. That's when that would be relevant. And it seemed to me to be piecemeal. Let's assume that everyone said, we're not objecting to Mr. Collins' request, and then that's granted. Even if we don't address yours, well, you get it as well. And now we set a hearing to determine the merits of your other motions. That's the way I saw it. In which case, then we would have time for you to get those documents either stipulated to and admissible, or we would allow additional time if they're objected to, so that could be properly heard without unnecessarily restricting anybody. Does anybody disagree with that?
No, Your Honor, I believe that is, if my motion is unopposed and the court grants it, we have an extension. That at least takes that 23rd date off. That allows mom's attorney to, everyone have to review the parties and mom's attorney to get a date as quickly as possible so that she can have her motion. So that way, I think everyone's covered there if the court goes that route. So I have no opposition to what the court laid out.
Okay. Now, as I understand this case, and obviously this is not evidence, so nobody really needs to argue about this, but we had an underage mom, had children. We have a dad who is incarcerated. I'm not sure exactly why he's incarcerated. It may have something to do with all of those allegations. There's some allegations that mom admitted to hurting the child. I think that the department originally had the idea that they were asking not to have to provide a service plan, but then decided to provide a service plan, and that's where we are. So it would be sort of understandable if the department is not excited about wanting to do many more services when they didn't really think that there should be a service plan in the first place. Now, whichever way all that goes, it's certainly arguable to the trier of fact. I didn't get a chance. I could have had a chance. I went and did what I could on my own. Or, hey, I did get the chance and I took advantage of it. Those are things that could be intertwined in this next hearing. But let me start out, because this is the way I intended to handle it, which was, one, do we grant the extension? If we don't grant the extension, we've got to go to trial. If we do grant the extension, we have a minimum of 6 months to then figure out how do we treat mom, how do we deal with mom and her services, how do we deal with dad and any possible services, what's appropriate there, and then we address that. So first, is there anyone opposed to Mr. Collins' request?
I'm not opposed, Your Honor. I don't think we really have an option.
The department's not opposed to Mr. Collins' motion for
Ms.
the
Johnson?
reasons stated previously.
Considering I want an extension, we are not opposed to an extension.
And I understand that just by saying that, that doesn't mean that you have to necessarily stand in line with Mr. Collins' client. Ms. Torres?
Your Honor, we don't oppose it either.
Okay, Casa?
Casa's not opposed to the extension.
Based on your, Ms. Justice, based on your experience, training, and your knowledge of the facts of this case, is it factually consistent with the finding of cause?
Yes, I mean, I don't see anything wrong with allowing more time to see if anything can progress.
Is that in the best interest of this of the child?
I mean, we would like to find permanency. That's definitely something we want to do. However, we understand at this time an extension probably would be best.
Okay. All right. It is granted. Now, Ms. Johnson, how long do you think you'll need to be prepared for the next round, which deals with the services for mom?
Your Honor, I would need to have all the same witnesses that I have today, which is why I would ask that they be paused and told to come back. But I would say that we can get our side out probably an hour to an hour and a half, because I plan to move very quickly. It's very factually based. And then, of course, I'm going to be relying on the courtesy worker in Ms. Olvera's area. So I would say an hour and a half.
Mr. Nisenblatt, do you have an idea in advance what, well, first of all, I'm assuming, based on what we're doing, is that the department is opposed to the request. Is that correct?
Are we talking about the request for visitation now?
And I don't think it was just visitation, but it was other therapy as well.
Well, Your Honor, to be specific, it is to begin supervised, and we would like that supervision to be under the guise of family therapy. So we want to begin the family therapy, which we maintain that we've been stonewalled in the beginning.
So I will object to that characterization. So what's happening is this poor child was subject to this physical abuse, manifested in many ways, and also physical damage that's documented by the Dell Children's. So he's undergoing his own therapy and treatment. The child is at 3 years old, 4 years old. His kind of circle of trust is very, very tight and tiny. The child's therapist has not approved and does not approve right now to increase the number of people in his life. Right now, it's just Anna Escobedo and the therapist. they're trying to widen his circle of trust. But it's, you know, there's good days and bad days. They're working on it. That's where the department stands right now. Is I don't believe the psychologist who did the report is in contact with the child's therapist. I think it's maybe just kind of the general protocol that said, hey, you'll start family therapy down the road. But I think if we put those two professionals together, that might have a different report from that psychologist. I don't know. But right now, the professionals that are licensed to look into that issue are recommending to the department that we not support family therapy at this time. Not saying it will not happen. It might happen further down the road. Also, I think there has to be a little more information regarding the specific therapies that this mother, because we do acknowledge that she was raped by the stepfather, who was the father of this child. She had her own trauma given her young age. She also needs to be in a good spot or in a good place. So the department is not saying no. We're just right now, from the child's perspective and for his best interest, we're saying that we do not believe neither the mother nor this child are ready for the family therapy to begin.
And
Okay. And hold, Ms. Johnson, before I let you respond, let me.
And Your Honor, I sorry to interrupt, but also there's a condition that because of the incidents, there is a criminal investigation. The case is pending, and it could be, given the serious nature of the facts that we're dealing with. That's also another element that we have to kind of look out for, that we don't know yet, whether there's a felony charge, whether what happens. I mean, she is innocent unless or until proven guilty, and that hasn't happened. And so it's just something we have to all keep an eye on as well. Thank you.
Okay. Yes, ma'am, Ms. Johnson.
yes, and just because the door was opened on the allegations against Miss Olvera, I think it's important to note that Miss Olvera is engaging in everything that she's supposed to. She's being very open and honest with her therapist. Finally, I was able to get the therapy notes, which I'm sharing with Mr. Nisenblatt. And with regards to the school, like even when she was in Bastrop, she had tons of absences. Where she's at, she's doing absolutely phenomenal. She's getting awards, she's getting everything. There is one small issue in my client. I have to look into it more, Your Honor, but my client may have been coerced into admissions of any guilt in this matter. She was severely abused. There is a person of interest. There has been a small investigation opened in the Dallas area due to the therapeutic confessions that my client has made with regards to who may have actually hurt this child or instigated the abuse. And that hasn't had a lot of attention. And that I'm going to be turning over to, any criminal investigators that in order to aid in their investigation. But this is a situation where mom was raped from the age of 6. And there was very little help for her. Granted, the second person that assaulted her that caused the birth of this child was incarcerated, and that is great. But mom has been working very hard to overcome this, and had this incident occurred just a few months before when it happened, the department would have been taking custody of not just the child, but his mother, because that's how young she is. And I think when we get to final trial, some of the facts are going to be horrific. I realize my client may face perjury, but in her mind, perjury is better than the truth never coming out. So that she's working very hard. She's making great improvement. We haven't had a chance to get that evidence out. Mr. Nisenblatt can review all the documents that I provided as I got them. But to not have a light at the end of the tunnel, to not be able to at least engage in very closely monitored family therapy, at least by Zoom, even if it's sparingly at this point, I don't find that that would be in the best interest of the child. I don't find that that would even be in the best interest of mom, which I know is a secondary standard. But there's more to this case than there is. And I'm glad that we have the extension because we need more time to flesh it out, Your Honor.
Okay, so,
Your Honor, can I add something real briefly?
sure.
Amanda Carter ad litem for the child. One thing that the department didn't mention, but I do want the court to be aware of, this child has a physical therapist, an occupational therapist, a speech therapist. When COVID hit last March, all that therapy came to a screeching halt. And quite frankly, he's just now getting back on track. He's just now being able to get back into compliance with all those. So whatever happens, I do want the court to consider, he's just now being able to get back to, a quote unquote normal schedule. And so that's, imperative that he stays in compliance with all those therapies going forward.
Now, look, I want to, and I don't think that these are mutually exclusive things, which is best interest of the child. But let me focus a little bit on the department is entitled to take the position that mom did these injuries and is therefore should be excluded from further contact with the child, and we think we can prove it. But I'm not entitled to go down that route with them yet. I could be the trier of fact in the ultimate trial. We don't make presumptions. It could be a jury. Has anyone filed a jury demand?
No.
Okay. So
I would
that
like to work with the department more before going
right.
back.
And I'm not saying that you need to or have to. You have time. I'm just saying that whether it's me as the trier of fact or whether it is a jury, one of the things that by this whole process, while we still want to, the best interest of the child is still paramount, we need to make the decisions along the way to provide a fair trial. The department has their position. That could change, and it might not change. They're entitled to believe that if someone did this to a child, especially their own child, that they couldn't ever parent that child. That is a position that they can take. The department can take the position that Mr. Collins' client, having the age difference in the sexuality, puts him in a position where he could never parent. But I'm not being the trier of fact yet on all of those things. You're all entitled to take your positions on what the ultimate decision will be. I want, by this process, to put everyone in a position so that you can have a fair trial. I'm not saying that that means having play therapy. I'm not saying it even means visitation, but I'm not saying it doesn't. The question will be, what can we do in the best interest of the child that also provides a fair trial? It may be some limited visitation in the meantime. It could be that once we have a determination, then we would go through all of those things if mom doesn't have a rights terminated. I don't know, but I do want you to have the benefit of the thought that we need to provide a fair trial, whatever that is. If you can put your heads together and say this doesn't infringe on the best interest of the child, but it gives mom and dad the right to a fair trial, that's great. If you can't decide that between yourselves, then I will make that decision. We now know that we have extra time. It's even possible someone said, well, we want this all to be delayed until after criminal proceedings are completed on mom and dad. There is a way to do that. I'm not saying that couldn't be the possibility. We don't want to wait too long. That may not be in the best interest of the child. What are the interveners' role in this? Are they just want to be in and then support the department, or are they taking a divergent view? Now that we're going with an extension, I don't think there could be a real challenge to the interveners being in, but the department filed and they're entitled to push the litigation in the way that someone who made the original petition can do. So let me get my coordinator on. Jennifer, where are you? Oh, there you are at the bottom. I'm sorry. What does next Tuesday look like on our docket? Is it too heavy?
Really.
What is it?
It's not bad.
We could have a 2-hour hearing at some point.
I have an all-day matter, Your Honor, that day.
Okay. All right. Well, then okay, here's the deal. It's more than likely has to be on a Tuesday. We do have a little more time. It doesn't have to be in a week, but as soon as we can, that fits with everybody, then maybe I'll just let y'all confer. Tuesdays are preferable. I may have to go a different date if we can't, but we have been having all of our CPS matters on Tuesdays.
Can we use the date of the final trial to discuss this supervised visitation issue?
This, we talked about doing the docket March 9th.
Okay, but what if
Is that
we
too
went back,
soon?
go back on the 23rd? That's when it was gonna be. And we were set for 2 hours anyway, right? Okay. Well, that makes sense. Let's do it on the 23rd since we were gonna do that anyway.
Oh,
And Your Honor, is it possible that we pause all the subpoenas issued as that way my client doesn't have to bear the cost of it's going to be
The court specifically extends all subpoenas that have been issued and served till February 23rd at the date that we will give. Let me explain again. I mean, not again, but to you, I've been trying to explain to everybody. Our normal docket, when we were live in person, we always started at 9 o'clock. And we just had, everybody was set at 9 o'clock and we just went. You were going to be here anyway, so we tried to take up shorter matters first, longer matters later. We could start at 9 o'clock and leave you all in the waiting room until your case is called and you sit there all day. I have preferred, as a convenience to the parties and to the attorneys, to not do it that way, that you get your specific time. Now, the problem with that is that we can't overbook. You know, if we have, we can't set more than 6 to 6.5 hours of docket because everybody has their specific designated time. So it will be a specific designated time because I feel like that works best for all of you. Jennifer will give you that time based on what other things we have on the docket. I don't know what we have on the docket that day, but she'll look into it and give you a specific designated time. You are all ordered to appear that day at that time. Ms. Johnson, would you give me a short order that extends the subpoenas?
Yes, Your Honor.
Okay. Are there any other issues that someone wants me to address? Ms. Torres, I am going to ask you at that hearing what role you think your clients are playing. Are you diverging from the position of the department, or what exactly that intervention might mean? You don't have to do that today, but I am going to want to know just for the sake of knowing how to handle the litigation.
Will do, Your Honor.
Okay, anything further?
No, Your Honor.
Okay.
Oh, yeah.
And Mr. Nisenblack, will you draft the order that says the extension is granted?
Yes, Your Honor.
Okay. All right, thank you. This will conclude the hearing.
Thank you, Your Honor. Bye, everyone.